My name is CJ Schneider. I am one of the attorneys in our litigation section here at Miller Johnson, and I specialize in supply chain issues, right? From contract formation all the way through litigation, if that's where it ultimately ends up. And with me today is my colleague, Jacob Carlton. Jacob, you want to introduce yourself?
Yeah, hi, everyone. My name is Jacob Carlton. I'm an associate here at Miller Johnson's litigation group, assisting CJ on a lot of these supply chain disputes. I also specialize on the insolvency side, counseling clients in bankruptcy-related matters and receivership-related matters in both supply chain context and otherwise.
Awesome. So we'll go through what we see as some of the big trends and topics in supply chains right now. So there's four buckets of topics we want to cover. There's a number of issues under each of these, obviously, but we want to talk about, the big I word, inflation, that's putting pressure on everybody. We broke out price increases as a separate topic unto itself because that's probably the main thing that is going on right now, right? How do you deal with pricing in an inflationary environment like this? Then we'll talk a little bit about insolvency considerations and what you need to be thinking about if you're either a distressed supplier or if you're a buyer with a distressed supplier, because for better or for worse, we are seeing some of that start to creep back to the forefront. It's been in a lull for a number of years, but with this inflationary pressure, we're moving back in that direction. And then the last topic we want to cover is a couple of key developments in the law on requirements contracts. That's not something that gets changed very often in Michigan, but the Supreme Court has taken up a case that I think may result in some significant changes in how requirements contracts operate in the automotive space and in potential other industries as well. So let's start with inflationary issues. The charts you see here are, I'm sure, charts you all have seen plenty of times before. They probably don't need much of an explanation. And we've seen cost of materials, cost of labor go through the roof in the last 2 years. And, in some months they recede a little bit, in some months, they're back up, but the trend line is definitively up and in a very, very steep way. I mean, we're in the hottest inflationary environment in the last 40 or 50 years. Same thing with the labor market. When you're talking about wages and just the need to get people, this is one of the tightest labor markets. And of course, put materials and labor together, and those are the biggest cost drivers for virtually any production process. So we've got to talk about how that impacts contracts and pricing and everything else. There's a couple of unique issues we see in supply chains, right? So the inflationary pressures obviously hit everybody, right? It almost doesn't matter what industry you're in. But when you're talking about supply chains, whether it's automotive or aerospace or mass transit or what have you, there are a couple of unique issues that we need to keep in mind. The first one are long-term agreements, or in the automotive world, we call them life of the program agreements. Those can lock in pricing for 5, 10, 15 years, right? So some of these contracts were made years and years and years ago when inflation was not doing what it's doing now. And parts you might have been making a healthy margin on, or maybe eking out a margin on in 2018, 2019, you may well be underwater at this point. You see your materials and labor go up by 40 or 50%, and that margin not only evaporates, but you end up negative. So rather than making a buck on every part, you're going negative on every part, and that's just not a sustainable way to do business. So from supply chains, those are usually the first agreements to take a look at, right? The ones where you have the most pressure because they're old and they've got old pricing. The other issue we see a lot is the pressure created by just-in-time supply chains. That's common in automotive, it's common in some other industries, but it really creates some leverage for sellers, or can create some leverage for sellers, and can create some vulnerability for buyers, right? So if sellers need or want a price increase and you've only got a couple days of supply on hand, they can make it pretty painful for a buyer to have to go through those negotiations. Maybe they don't shut you down, but they can certainly make it very, very difficult. So one of the things we've seen buyers doing, and frankly, we've counseled some of our buyer clients to do, is consider adding to your safety stock of critical parts, in particular critical materials, so that if you do have a seller or even any type of shortage that might happen, you at least have a little bit of buffer so you can take a big deep breath and try to figure out how you're going to solve it long term, rather than reacting in 24 or 48 hours, as is sometimes the case. The last point is an obvious one, but we have to say it, right? the material and labor shortages are compounding the inflationary pressure. Material shortages seem to be lessening. That's certainly not to say they've gone away. That's not true at all. But they don't seem to be as bad as they were a year or two ago. The labor shortages seem to be the key thing, at least from what we are seeing. We're just finding people and then getting them to stay is the most common issue and one of the most common pricing issues that we've seen.
Yeah. So when the COVID hit in March of 2020, a lot of these suppliers were relying on the contractual doctrines of force majeure and commercial impracticability to kind of either force through a price increase or to stop shipment or to, somehow excuse their performance under these contracts. Now that the national emergency of COVID has subsided a little bit and we're 2 years into this pandemic, those arguments have gone away a little bit. Courts are not as likely to allow you to point to COVID as an excuse for non-performance like you could in 2020 and maybe even a little early in 2021. There's been some cases where the judges talked about if you've signed a contract when COVID existed, you can't look at the impact of COVID as an excuse to not perform under the agreement. So while that kind of excuse, we can call it, worked in 2020 and maybe early 2021, it's less of an option now available for the suppliers. So we need to look somewhere else. Generally speaking, and again, force majeure is a contract by contract specific argument. Force majeure depends on the language of the contract. Generally speaking, it's not an option to cite inflationary or labor costs or material and price increases as an excuse under a force majeure contract. And so we have to look elsewhere into these terms and conditions to try to figure out what leverage we have to excuse performance.
And I'll add one piece on that before we talk about price increases, and we'll get to some of this on contract negotiations later. But to the extent you are negotiating a contract, give some thought to what that force majeure clause says, because as Jacob says, it's all a creature of contract. So whatever's written in the contract controls. If you can get to an agreement where you have a force majeure clause that calls out interruptions in supply or inability to get materials or labor from usual sources or similar type events, an epidemic, pandemic, you can certainly rely on those. It all depends on what goes into the contract. So the older force majeure clause is less likely to give you help, but certainly if you can negotiate some key language into new force majeure clauses, you set yourself up to be able to use them later on down the road. So let's talk about price increases, because this is probably the 7-day-a-week issue right now. So we're going to talk about these both from the supplier side and then from the buyer side, because there's a couple different ways to think about this, right? I mean, there's no doubt that reasonable price increases are something of a necessity. I think even most ultimate customers have recognized that by this point, even if they're not willing to say those words out loud. They, by their actions, have been even begrudgingly starting to give some price increases. So we're seeing suppliers and have seen suppliers for the last year or more seek mostly necessary price increases. And I say mostly because one of the things you got to watch out for on the buyer side is making sure you don't get taken for a ride, right? I mean, suppliers need to ask for what they really need in order to keep the lights on and keep the supply chain healthy. But you've also got to make sure that they're not padding their profit margin and using the current economic circumstances as an excuse to do that. So if we put our supplier hats on for a minute, there's really 4 common strategies that we see. The first one is the business case. And this is usually where most people start. And I think it's probably the right place to start. And this is simply an appeal to your customer. Hey, this is the issue. We're upside down on these parts, or materials gone up 20% or whatever that happens to be. Can you, give us a price increase? Here's what we need. And that dialogue is sometimes diplomatic and everybody works together. More often than not, it escalates at least a certain level. Ideally, you get to some type of agreement before you end up getting the lawyers involved, but somewhere along the way, the business case starts to break down. The second strategy, if you can't get it just on a business case, is to start picking apart the contract. And that's usually where we end up getting involved. So your contract can be a lot of different things. Your contract can be a long-term agreement, like we talked about before. Your contract can be a purchase order, scheduling agreement, set of terms and conditions, letter of intent. I mean, it depends on whatever the governing document is. And we take a look at those and we try to find the leverage points in those contracts, because different buyers have different levels of sophistication with preparing their contracts. And almost always, not always, but almost always, there's some type of leverage in there we can at least use to make an argument for a price increase. And sometimes we have to marry that with the business case, right? One of the common things is to combine 1 and 2. So the business folks will make their case, we'll pick apart the contract, and we'll put together a correspondence that says, listen, here's why we really need this price increase, right? This is something that the business actually needs. But aside from that, buyer, you've got problems with your contract, and if you're not willing to work with us, we've got reasons to exit the business or to otherwise change the price, right? I mean, it's kind of a 1-2 punch, if that makes sense. The third step in escalation, if we're really not getting any traction, or frankly, if it's a supplier that has some critical funding issues, right? If we're starting to see cash shortages, those kind of things, is to get outside help involved. And these can be industry consultants, groups like Riveron. There's a bunch of different ones that do this kind of work that can help come in and on a holistic basis evaluate the book of business of the supplier and try to get the customers in a position where they're willing to support collectively some type of price increase. You can also do this through funding partners, right? Sometimes common banks will help on this kind of issue. That's a little less common, but we have seen it happen. The fourth strategy is one Jacob will elaborate on here in a little bit. And I hesitated to put this on here because you don't want to make this as an empty threat, right? It's very effective, but it has to be true in order for it to be effective. So if you're a supplier and you are truly upside down on a core chunk of your work, right? You got a customer who's 70-80% of your business, or a couple of customers that make that up, and you are just underwater. Honestly, one of the most effective things to say is, listen, if you all don't help us out here, we're going to go out of business. And the reason that's effective, assuming it's true, right? You don't want to make that as an empty threat, because if you get called on your bluff and it's not true, that's going to hurt the relationship. But if it's true, most buyers recognize in this environment that it is going to cost them more money and result in a higher price to resource the work. And oftentimes there are collaborative agreements that you can get to with buyers to help you get over the hump and get to a better place, a healthier place financially, to keep the doors open. It's not an easy process. It's not a fun process, but it can be done. So the last 2 bullet points, aside from the strategies, are just things that we always tell suppliers to keep in mind. So when you're a supplier negotiating a price increase, it's very much a game of chicken, right? You want to bring as much leverage as possible, but you don't want to end up in court. And the reason you generally speaking don't want to end up in court, the reason you generally speaking don't want to end up in court is that once you do, you lose control of the negotiations. The judge is going to start making decisions on what the contract says and what's enforceable and what's not. And generally speaking, in Michigan, most judges are going to err on the side of preserving the supply chain. So what that means as a practical matter is that if you end up in court over a price increase dispute, chances are the judge is going to order the supplier to keep supplying at the current contract price pending the outcome of the dispute. Now, maybe they make the buyer escrow the price difference. Maybe there's a bond. There's a couple of different things that might happen to the buyer. But generally speaking, if you're walking into court as a supplier, you should expect, at least on a temporary basis, that the court is probably going to keep you producing parts. So the way we always advise clients on this is you want to get right up to that line, right? You want to say all the things you need to say and do all the things you need to do to put maximum pressure on the situation, but without tripping the wire to get into an injunction. And there's certain key elements of an injunction that we will take longer than today's presentation to walk through, but you want to make sure you steer clear of those just enough where you don't end up in court. The last bullet point on here is about leveraging the market, right? And this is a point I made earlier when we talk about making the business case or engaging outside help. I think most buyers recognize that if they move work from a supplier, they're going to be eating a price increase, not to mention the cost to either retool or move the tooling or build a bank or whatever it happens to be. And so, if you have leverage in the contract, or if you have a good relationship with the buyer, think about that from their perspective, right? In most circumstances, they're going to want to keep the work with the supplier, because the supplier, assuming it's an older contract, has more favorable pricing than what they might otherwise be able to get in the market. Now, the flip side is also true, right? If you have a contract that is so buyer friendly that you have no leverage, they may well just decide to say, listen, we're going to enforce the contract, and that's the way it is. So it's a consideration you got to keep in mind and play that card when it's right to do so with the right contract. All right, next slide. So from the buyer side of the table, the biggest concern is which price increases are legitimate and how much of them can we actually give without putting ourselves underwater, right? I mean, because just because suppliers are asking for the price increases doesn't mean the buyer can absorb them, and it doesn't mean that they're legitimate. So a lot of this is about separating the wheat from the chaff and then making sure you're keeping an eye on your own bottom line, or being able to go to your own customers with enough information and say, listen, we need to spread the pain around here. So a couple of common strategies here, right? The first one I always tell folks is do a contract checkup. If you haven't done this in the last year, you probably should. Look at your key supplier contracts, right? Ideally, you do them all, but if you're large enough where that's too many suppliers, look at your critical supplier contracts and make sure you have fixed pricing contracts at the quantities that you need. That's a requirements contract. Make sure it says that in no uncertain terms. And we'll talk about that when we get to the case law. If you have a certain number, quantity you need on a yearly or monthly basis, make sure it says that. But do a contract checkup to make sure you have what you need in place, because as I said on the last slide, one of the first things suppliers are going to do if they feel pressure to get a price increase is go see what their exit options are under the contract. And you want to make sure you have that locked up before that issue arises. The second strategy that everybody does, so I'm not going to spend a ton of time on this, is request a bunch of detailed information from the supplier, right? This is about separating the wheat from the chaff, getting the legitimate price increases from the ones who are perhaps trying to pad their pockets. And that's everything from getting invoices from material suppliers to quotes to, you know, whatever the documentation is. And that, I mean, that's not only good for your own business to make sure that you're seeing what the supplier's true costs are, but it also helps if you've got to go to your ultimate customer, an OEM or what have you. Now, different suppliers are willing to share different levels of information. Most of them are not willing to be completely open book for a whole host of reasons. But generally speaking, the ones who truly need the price increases for legitimate reasons will be willing to provide some reasonable amount of supporting information to show you, yeah, my materials have gone up by 25%. And here's the invoice to prove it, right? Things like that. The third strategy we see commonly is share the pain, right? So, you know, you go to your OEM customer, you go to your supplier, and you try to get everybody to take a slice of the pie so that you as the tier 1 buyer or tier 2 buyer, whoever it happens to be, aren't eating the entirety of the price increase. That works to varying degrees depending on the supplier and the OEM and what kind of leverage you have as a buyer. And so sometimes the buyer has to wear both hats, right? You got to look at both your seller contract to your OEM customer and your buyer contract to your supplier and figure out what's the best way to try and make that ask to both of those entities. The fourth option is to resource the work, right? If you are truly in a position with a supplier where it's not working, or you have a distressed supplier who, you know, you think might be folding, you need to consider resourcing options so that you protect yourself with your ultimate customer. If a supplier shuts you down and you shut your supplier down, it's all well and good to tell your supplier, hey, listen, you're on the hook for all these damages, but if 3 weeks later they file for bankruptcy, the chances of you getting any damages out of that supplier are slim to none. So you got to keep an eye, particularly on critical work, and make sure that it's with a stable supply chain. The fifth strategy, and this one probably should be up the list a little bit further because it happens more and more frequently. If you are a buyer with a solid contract with your supplier, like if you have solid terms and conditions and you have a requirements contract and it's fixed pricing, don't be afraid of enforcing the contract in court, especially if you have a supplier who isn't acting reasonably. It's very common to run into court, seek a temporary restraining order or a preliminary injunction, ordering the supplier to continue to produce parts at the current price in the contract while the dispute gets resolved. And usually at that point, you start to see the supplier get a little more reasonable because now they're not just making arguments to you about why the contract's invalid or why the price needs to go up. They've actually got to make those arguments to a judge and justify those arguments to a judge. So if you've done number one, you've done your contract checkup, and you are confident in the health of your contracts, don't be afraid to enforce them in court. That can be one of the most effective strategies on keeping the supply base in check. Next slide. So we've talked about price increases on existing contracts. So what do you do about new contracts, right? If you're getting sourced new work, or if you are the lucky recipient of resourcing of some work, how do you deal with those? So on the supplier side of things, we've been telling folks, listen, you've got more leverage than you have in the past 5 to 10 years, right? The supply base is tightening, prices are going up. There's fewer and fewer places for buyers to put work. And so you've got more of an opportunity to negotiate a better contract. So in the past, it was real common. You just took the buyer's terms and conditions and you ran with them. You didn't really negotiate anything. I would say take the opposite approach now. Take a look at the contract documents, look at the purchase order, look at the buyer's terms and conditions, redline them. If you can get away with it, incorporate your terms and conditions so that you can leverage the good work on the seller's T's and C's. The other thing you want to consider is escalator clauses for material. I've seen them indexed to inflation. The producer price index inflation model is pretty common. There's other ones. But certainly put those escalator clauses in there so you're not fighting every 6 months or 2 months, as the case may be, over new inflationary data. The other 2 points are really more nuts and bolts of contracts, but to the extent you're worried about quantities or price and payment terms, make sure they're addressed in the contract. So, requirements contracts will not guarantee a particular quantity, but sometimes you can get a buyer in this environment to say, okay, we'll commit to a minimum of X, right? It's not going to be the whole kit and caboodle, but you'll at least have some kind of guarantee that you're going to be able to get parts shipped and paid for. So just keep in mind there's a little more leverage there. For buyers, we've talked about enforcing favorable existing contracts. You probably want to minimize resourcing as much as possible because you're going to have to go through the negotiation piece. When you are in a position where you're sourcing new work or resourcing old work, be prepared to negotiate with the supplier, right? That doesn't mean give away the farm. It doesn't mean you have to accept the supplier's terms and conditions, but reasonable concessions on your own terms and conditions can go a long way in getting a deal done, and most of the time not do too much damage as long as you're mindful about what you're giving on and what you're holding back. The last piece that honestly I don't see enough buyers push for, and I'm not sure why, but think about putting in price clawbacks. If you're going to have a material escalator clause in there, it should go up and down, right? Or if you're going to have an inflationary escalator, up and down. Or if there's some other way the prices are getting adjusted because of the maelstrom we're in with the market right now, have some type of clawback mechanism in there so that you get the benefit of the downswing when that ultimately happens at some point here.
Yeah, thanks, CJ. Just want to talk a little bit about, in the insolvency context, the bankruptcy word that everybody's always so scared of hearing. Whether you're a supplier, you don't want to mention the word bankruptcy. You're afraid of what that might mean for you. If you're the buyer, you're really scared to hear if a supplier is telling you, hey, we're considering bankruptcy as an option. That bankruptcy word makes everybody press pause because they don't usually understand the complexities of the bankruptcy code, the bankruptcy court system, and the rights and options underneath the code. I want to talk a little bit about what this means on the supplier side. To start with, if you are a supplier and you're looking at your numbers and can't figure out how you're going to survive this inflationary period that we're in, one of the things you should do as soon as possible is contact your attorney to discuss what your bankruptcy or receivership options might look for you. Oftentimes, when somebody hits the point where they can't make it anymore, they call their attorney too late. The bankruptcy code has lots of different options for a distressed supplier to go through, and we'll talk about what those options are in a little bit here. But some of those options are only available if you talk to attorneys soon enough that they can put you in some of these reorganization plans. So the first thing you should do when you're looking at your books and trying to figure out how you're going to survive this period is go get counsel, talk to an attorney, figure out what options are available to you under the bankruptcy code and what options you may have. The next thing you should do is make your case to your customer. this one, you want to talk through your attorney with how you're going to approach this, but your buyer does not want the supplier to enter into bankruptcy court, because that causes the buyer a lot of issues. And we've often seen, again, with, like CJ mentioned, when it's true and you can make the statement truthfully, that if you don't get some sort of release on this contract, that you're going to be insolvent, you're going to have to close down your doors, and you might have to declare bankruptcy. If those statements are credible and you can show that those statements are true, your customer is likely going to step in and help provide support in one way or another. And there's lots of ways the buyer can support. Sometimes it's through a price increase. Sometimes it's through some sort of joint venture agreement where the buyer comes in and starts purchasing a portion of your company, and you can operate that entity in a joint ventureship. There's lots of options that your buyer have that could help you. And if you can make the case about why you need some price increase or you're going to go insolvent, consider talking with your customer about that. The third option, obviously, is talk to your lender. Your lender doesn't want you to go into bankruptcy either. Nobody wants to see you end up in bankruptcy court, because that causes headaches for your buyers and your lenders. And so talking to your lender as early as possible in this process to show what is going on, you might be able to come up with options from your lender to avoid the bankruptcy. Once you get into the point where it looks like bankruptcy is really your only option, there's multiple options within the bankruptcy code itself. The simplest option typically is a Chapter 7 bankruptcy, which is where you just submit all your assets of the company to the bankruptcy code. The court appoints a trustee. The trustee sells all the assets of the company and distributes whatever proceeds to the creditors. There's options within here. You can talk about trying to arrange what's called the stalking horse bidder, which is where you get somebody to come alongside you before you declare bankruptcy to purchase your company, and use the bankruptcy code as a way to shield that buyer from your creditors. There's lots of options within the Chapter 7 context. And these are all stuff you should talk to your attorney about, whether a Chapter 7 or Chapter 11 is right for you. Chapter 11 is by far the more complex chapter of the bankruptcy code. It allows you to maintain possession of your assets while you're going through this bankruptcy period, and it requires you to essentially renegotiate your debt with all of your creditors through the bankruptcy court and get bankruptcy court approval for what's called the plan for reorganization. Now, there's lots of nuances that I can't get into in this short time period we have in Chapter 11. It's a very technical process. And again, this is why you want to consider talking to an attorney early on, because there's a lot of benefits of a Chapter 11, but you have to be able to put yourself in a position where a Chapter 11 plan can get affirmed. And the only way to do that is to plan this out meticulously ahead of time, and get all your ducks in a row before Chapter 11 is filed. There's also a downside of a Chapter 11, though, is if you can't continue to make payments during the process of the Chapter 11 bankruptcy, you could be forced into a Chapter 7 bankruptcy and be forced to sell the assets of the company. Lately, we've also seen a rise in receivership actions. Some of these secured lenders have gotten themselves in better positions to come in and take over control of the company once the company starts to turn insolvent. We've also seen an increase in some of these suppliers going to their lender and jointly agreeing to a receivership process of some sort. Receiverships vary state by state. It's a state law process, and we're seeing a rise of these in Michigan, and we're seeing a rise of these kind of across the country now. So that is also an option. If you don't want to go the federal court bankruptcy route, you can work with your lender and talk about what a receivership might look like. That is often a good plan for somebody who has some outstanding personal guarantees, because oftentimes you can attempt to negotiate limitations on those personal guarantees through a receivership action that's controlled by your secured creditor. So if you're someone out there that has extensive personal guarantees, you might want to talk to your attorney and consider what that receivership option might look like. On the flip side of this, there's lots of things that the buyer dealing with a suppressed supplier should consider. First of all, what do your terms and conditions say? You should take a look now, as this inflationary period is continuing, What are your termination rights? If you're in a life of the program requirements contract, what are your rights to terminate that contract in the event you have a supplier who's considering or threatening bankruptcy? We strongly encourage some of our buyers to have language in there that talks about, even on the hint or threat of bankruptcy, is a material breach of the agreement that allows the buyer to terminate the contract in whatever manner it sees fit. We have to be very, very careful about those clauses, however, because once somebody actually does declare bankruptcy, the bankruptcy code prohibits you from making certain contact and doing certain things with an entity who has declared bankruptcy. So once a bankruptcy has been declared, you should contact your attorney to talk about the effect of that bankruptcy on your contractual rights related to that supplier. Another thing you should talk about, and CJ touched on this earlier, is if you have a supplier coming to you mentioning that they're distressed, mentioning the bankruptcy word or some sort of insolvency, you should really start building up both a material bank of raw materials for the part in case you need to move to a new supplier pretty quickly, as well as a part bank, parts that will get you over the month or 2 months or 3 months it might take to transition this work to a new supplier. Once a customer comes to you and talking about their financial condition, there's potential for business solutions. We have seen in some contexts with a tier 2 supplier or even a tier 1 supplier who's starting to fail or look like they might fail. The OEMs have, created these limited joint ventureships where the OEM will actually come in and purchase a portion of this business and create a new entity where the OEM is a direct owner of some of these suppliers to protect the supply chain. And there's a lot of creative options you can have when it talks about some of these business solutions, whether it be a limited partnership, a joint ventureship. There's lots of options to think creatively to come up with a business solution to the insolvency to protect your supply chain while this issue is going on. Finally, when you need to make sure you're protecting yourself when looking at whether or not you have protected security agreements. Most of these buyers, especially in the automotive supply chain, have some sort of tooling agreement where they have tools placed at the buyer's location. What are your security rights in those tools? Do you have the proper terms and conditions in either your bailment agreement or your standard terms and conditions that talk about whether or not you have a secured interest in those tools? Do you have your UCC filings up to date? UCC filings, the default is they expire every 5 years. Have you been keeping up to date with your UCC filings? Have you filed them in the right jurisdictions? I think now, especially as the market is heading the way it is, I think everybody should take a step back and look at, are they up to date with your UCC filings? That is, I think, something that's going to rear its head as more and more suppliers are becoming distressed, and there might be fights about who gets preferred secured rights or who is just a general unsecured creditor. So I would strongly recommend, on the buyer side, either right now as a matter of course across your industry, if you can check on, the status of your UCC filings and your security agreements, and especially do it when a supplier comes to you talking about insolvency.
All right, so the last segment we want to talk about is some of the legal developments we're seeing on the requirements contract issue. And if you want to go to the next slide, Jacob, we'll cover a little bit about what is a requirements contract, because sometimes there's a little bit of confusion over this. So generally speaking, just a level set, a requirements contract requires a supplier to sell and requires a buyer to buy some or all of the buyer's requirements or needs of a particular good. A lot of times we see these as sole source or 100% requirements contracts, but they're not required to be that. You can see a dual source or multi-sourced requirements contracts where each supplier has a certain percentage of the buyer's requirements. So 50-50, 60-40, 70, 15-15. I mean, they come in all different flavors, but usually it's a sole source 100% requirements contracts. And in Michigan, the rule is, and it allows those multi-source requirement contracts. It doesn't have to be an exclusive contract. So what do you have to do to have a valid requirements contract? This all comes out of the Uniform Commercial Code, which is codified in the statutes that where you see at the bottom, 442-306. these are pretty basic requirements, and then you get into all the case law on top of it about what actually creates a requirements contract. So real basically, in a requirements contract, the buyer has to determine the quantities it needs in good faith, right? So it has to determine its actual good faith requirements and purchase those from the seller. The quantities that the buyer purchases can't be unreasonably disproportionate to stated estimates or previously purchased quantities. And that's an often overlooked provision of this UCC, because what happens, particularly if you're launching a program, sometimes the volume goes through the roof because it's a popular program. They're selling a lot of vehicles or whatever it happens to be. And on the other end of the equation, sometimes total flop, and you end up selling way fewer parts than you thought. There's some case law gloss on top of that that says that provision really only applies when the quantities are too high. It typically doesn't apply when they are too low, but it is certainly something that you should be taking a look at on the supplier side if you're having an issue with the quantities that your buyer is buying. And then the last part of it is, go back one real quick, Jacob. So the last part of it is, I can cover this, is that when you are the seller, you've got to use best efforts to provide the buyer with the products, right? I mean, you can't just be a wet noodle about this. That kind of goes without saying, but those are sort of the three key components. All right, next slide. So there's two cases we want to talk about. The first one isn't as new. The second one is brand new. So the first one came out a couple years ago, and it's Cadillac Rubber and Plastics versus Tubular Metal Systems. This was a case that was in the Oakland County Circuit Court and went up to the Court of Appeals. The reason we want to talk about it today is twofold. First, I don't think enough buyers realize what this case means for them. And conversely, I don't think enough sellers realize how much it harms them. And the second is that I think this case might be driving some of what the Michigan Supreme Court is currently looking at in the Airboss case, which Jacob will talk about here in a second. So the way this worked in Cadillac Rubber and Plastics, this was an automotive supply case. The buyer in that case, which was Tubular, purchased a number of different products from Cadillac, and the terms and conditions created a blanket order, right? It was a blanket purchase order, and it created an option contract. What it said was, in exchange for $10 that would be paid at the end of the program, the buyer would purchase somewhere between one part and 100% of its requirements, didn't have to tell the seller how much of those requirements it was actually going to buy, other than it got to send material releases whenever it felt like it. And the term of the contract was for the life of the program. So Cadillac took the position, I think we can go to the next slide, Jacob. Cadillac took the position, listen, this isn't a requirements contract. This is a seller or buyer gets to buy whatever the heck buyer wants contract. Tubular obviously took the position it was a requirements contract. And the Court of Appeals ruled in favor of Tubular. It said this option scenario with the magic language that's in there is a requirements contract. It also ruled that there was not an indefinite quantity term, even though it was somewhere between 1 and 100% of requirements, that it didn't violate the UCC's requirement that you have to have a quantity in writing. So, and then it also went on to talk about exclusivity of requirements contracts, which honestly, I'm not sure the court needed to address, but it did. So what does this mean, right? This is the practice tip at the bottom. This is huge leverage for buyers. What this case means is that if you mirror the language that is in this Court of Appeals case, you can effectively create a requirements contract that allows you to decide whatever you want to, whatever quantity you want to purchase from the seller. So you can, as long as you buy one part, you've satisfied your contractual obligation, you can buy up to 100% requirements. But if you find another supplier with a better price, you can move the work. You don't even have to terminate supplier number one because you've already bought one part from them, and resource the work without paying any cancellation for convenience fees to supplier number one. It's huge, huge leverage for buyers. And we routinely advise buyers when you're doing a terms and conditions update to put this language in there. Although with this next case, we're backing off that a little bit because I think we might be swinging in the other direction here some. But at least for now, this is the law in Michigan, and it's something buyers need to be aware of. And sellers, this is something you need to be aware of as well. This is why you need to be redlining your buyer's terms and conditions, because if it has this language in there, you need to have an upfront conversation. Hey, are you buying all of your requirements from me? Are you buying 50%? How is this going to work? And you should tell me how much of your requirements you're going to buy, right? 50, 75, 100%. And let's put that on the face of the purchase order so everybody's clear about what this contract actually says, and we're not guessing at a number between 1 and 100% of requirements. So if you can't tell, I have a pretty strong view of that case was wrongly decided, but I'll get off my soapbox now and Jacob can talk about the next case.
Yeah, and why this case, the Cadillac rubber case, really, I think sets the stage for this next case that's currently in front of the Michigan Supreme Court, and that's MSSC Inc. v. Airboss. Airboss was decided last year by the Michigan Court of Appeals and involved a contract that was what's called the per releases blanket purchase agreement. So the contract did not specify any particular number of parts. It was just labeled blanket. And it says, we'll tell you in standard releases how many parts we are going to order. The question in that case, the UCC, the Uniform Commercial Code, requires that contracts specify a quantity term. And, MSSC was arguing that per releases language was insufficient to state a quantity term. The Court of Appeals decided that, blanket was use of the word blanket was imprecise. It is sufficient under the UCC to state a quantity, and talked about the benefits of that decision and that it provides flexibility for the buyer as production schedules changed. And it was generally the common practice that we see in the automotive supply chain. The defendant, unhappy with that decision, appealed to the Michigan Supreme Court, and the Michigan Supreme Court decided to take the case. Now, the Supreme Court could do lots of things with it. It could, just decide to affirm it without an opinion. It could decide to reverse it. It could impose some new standard of what language is going to be needed in a requirements contract. The question the Supreme Court is going to determine is whether or not just the use of the word blanket and this phrase that we can tell you how many parts we want to order in a per release, in a standard release, whether that satisfies the UCC's quantity terms. And anytime the Michigan Supreme Court rules on an issue that is of this nature, I mean, almost every OEM in Michigan uses this form of language. Most of the tier ones, tier twos use language that is similar, a little bit different, a little bit nuanced from this. And this Supreme Court opinion could really change the way we put these terms in the terms and conditions, and it could really change the way that current contracts interplay with one another. So it's certainly something to look out for. We don't know when the Supreme Court will make its decision on this case. It could come any day, but it's certainly something to look out for as you're considering changing your terms and conditions or updating them.
So let me just add one thing at the end. It is very unusual for the Michigan Supreme Court to take up a case on a UCC issue, and in particular on a requirements contract. The reason why I have my eye on this case in particular is because my magic 8-ball, which is as good as everybody else's, suggests that they are going to say something about how requirements contracts are formed in Michigan. I suspect that there is some fallout from the tubular metal case that I just talked about that the Supreme Court may try to clean up here. And so one of the things, whether you're a buyer or you're a seller, particularly if you're a buyer, is you want to make sure that for your critical supplier contracts, the ones you absolutely cannot have go haywire, that you look at those and make very clear that if you need them to be requirements contracts, that they are requirements contracts. And that's easy to do, right? You can do it with a couple of words. This is a 100% requirements contract. I mean, you just leave it without any ambiguity. And so, while you certainly want to take the benefit of the law as it exists now and try to leverage the 1 to 100% requirements piece, if there are contracts that you can't afford to have go haywire, consider just making a very firm statement that they are requirements contracts. That way, when the Supreme Court makes its ruling, you're not left scrambling to clean up your contracts. Because when the ruling comes down, it is likely that it's going to take immediate effect, right? And it may even have some retroactive effect, although that's a whole other issue I won't get into right now. We do a whole presentation on retroactivity of Michigan Supreme Court opinions. But be prepared that when this ruling comes down, there may be a scramble to clean up contracts, and you don't want to be in that position with your critical suppliers. So I'll stop there. And that's all we have for you folks. If you have any questions, feel free to put them in the chat. Otherwise, you are more than welcome to contact Jacob or I. We're always happy to talk, even if it's just for 5 or 10 minutes, and see if there's an option for us to help you. Otherwise, I hope today's presentation was helpful, and we appreciate you tuning in.